Question. Does the Court of Tax Appeals have jurisdiction over a special civil action for certiorari assailing an interlocutory order issued by the regional trial courts in a local tax case? Answer. While there is no express grant of such power, with respect to the Court of Tax Appeals, Section 1, Article 8 of the 1987 Constitution provides, nonetheless, that judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law, and that judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. On the strength of the above constitutional provisions, it can be fairly interpreted that the power of the Court of Tax Appeals includes that of determining whether or not there has been grave abuse of discretion amounting to lack or excess of jurisdiction on the part of the regional trial courts in issuing an interlocutory order in cases falling within the exclusive appellate jurisdiction of the tax court. It thus follows that the Court of Tax Appeals, by constitutional mandate, is vested with jurisdiction to issue writs of certiorari in these cases. Indeed, in order for any appellate court to effectively exercise its appellate jurisdiction, it must have the authority to issue, among others, a writ of certiorari. In transferring exclusive jurisdiction over appealed tax cases to the Court of Tax Appeals, it can reasonably be assumed that the law intended to transfer also such power as is deemed necessary, if not indispensable, in aid of such appellate jurisdiction. There is no perceivable reason why the transfer should only be considered as partial, not total.